Hello and welcome to part 2 of the top 10 misconceptions of the Employment Tribunal. So straight in at number 6 is unfair dismissal is about reasonableness, not about fairness. Unfortunately, the test for unfair dismissal is what a reasonable employer would have done in the circumstances that you describe in your claim. It is not about fairness. The tribunal can think what happened to you was so unfair that they feel sorry for you. But if it's what a reasonable employer would have done in the same circumstances as you've described, then unfortunately you will lose your case. So it's about reasonableness, not fairness. Number 7, the tribunal can only make certain types of order. So this is more relevant if you win. So it cannot, for example, order your employer to give you an agreed reference if you win. It can only order compensation, reinstatement or re-employment. It can also make orders around terms and conditions. But it cannot order your employer to give you a reference or even an agreed reference if you win. Number 8, a tribunal will not clear your name. If you take your case to tribunal and you win, for example, for unfair dismissal, then you will still have been dismissed for gross misconduct on your employer's files. The tribunal cannot retrospectively change its judgment, replace its judgment for the employer's judgment. You will still have been dismissed by your employer, and you will have to explain that to future employers. Number 9, costs. Now, costs are rare in a tribunal. So if you hire a solicitor or a barrister and you win, you will be expected in all likelihood to bear the cost yourself. It's not like the civil courts where the party that wins has their costs repaid. It's very rare in the Employment Tribunal to have costs awards made, and only in exceptional circumstances will an employment judge consider an application. And number 10, finally, there are ceilings on the awards that employment tribunals can make. So please check your claim and value it appropriately. Most claimants will go to the tribunal expecting hundreds of thousands of pounds in compensation for the wrong that's been done to them. And bankers and other highly paid executives hit the headlines, and you see those in newspapers up and down the country about high employment tribunal case awards that have been made. They are the exception. So very briefly, and I'll read this so that I get it right for you. In 2022, 2023, the average unfair dismissal award was £11,914, the average. The maximum in 2024 unfair dismissal award is 52 weeks pay, so 1 year's salary, or £115,115. It's capped, but you can expect if you earn less than 115,000 to just get 1 year's pay as an absolute maximum. But the average 2022-2023 was 11,914. In discrimination cases in 2022-2023, for example, the race discrimination average award was £23,000, even though the maximum award was £452,474. The average for sexual orientation was 14,210, and probably the lowest was the average for age discrimination, which came in at 14,210. So please price your claim accordingly, and it will help you certainly in terms of negotiating settlement with the respondent, with your ex-employer, if you have the correct value of your case in mind before you take it to tribunal. So those are the top 10 misconceptions of the Employment Tribunal, and I hope they were useful to you. Thanks for watching.